Hello and welcome to our Taylor Wessing webinar on what to look out for in UK employment law in 2022. My name is Paul Callaghan. I head the employment law team here at TW in London, and I'm going to be joined by a number of my team members, Joe Aiston, Millie Kempley, Ruth Moffett and Alex Clarke, many of you who will know at least some of us. So what we're going to talk about today is a number of different issues. Millie is going to start by talking us through the UK rules on COVID. Today's a momentous day in terms of COVID history because as of today, even if you have COVID in the UK, you're not required to self-isolate. So very radical changes. The UK is largely seen COVID now as something that we just have to live with, get on with life and work with, and not have restrictions. But Millie will go into more detail about that. Joe's also then going to move on and give us a talk about return to the office issues. As I'm sure a lot of people on this webinar have experienced, there's been a big move towards hybrid models of work, partly at home, partly in the office. And Joe will talk us through the issues to think about there and the current trends. Speaking of trends, we're going to talk about what seems very topical, particularly in the tech sector, and that is companies moving to a potential 4-day working week and what that means exactly in terms of what you have to pay, what the obligations and the rights of the employees impacted are. Then Alex is going to talk us through a potential employment bill. We've been told that when parliamentary time allows, there will be an employment bill going through Parliament, and there are a number of different largely rights, but also potentially some responsibilities that possible bill will cover if parliamentary time is found. And also, Ruth is then going to take us through some big cases going through the tribunals and courts in the UK at the moment relating to employment law, and there are some very interesting issues in relation to holiday pay and in relation to particularly transgender rights and the argued by some people, occasional conflict of one set of rights of a protected class in relation to other sets of rights. So that's all quite interesting and very, very, very topical for us to deal with. So starting with Millie. Millie, what is happening in the UK when it comes to COVID and returning to the workplace and how we deal with employees who either have COVID or may have been exposed to it?
Thank you, Paul, and good afternoon, everybody, or good morning, depending on where you're joining us from today. As Paul said, I'm going to be talking about COVID restrictions, or actually the end of such restrictions, certainly in England today. So as Paul said, it's highly topical because on Monday this week, as part of the UK government's Living with COVID plan, it was announced that from today, 24th of February, all legal restrictions in relation to COVID-19 in England will end. Legal restrictions also come to an end in Northern Ireland, but for the rest of the UK, Scotland and Wales, such restrictions will end a little bit later. They have always been a little bit more cautious about dropping the rules compared to England. So those who test positive for COVID-19 will no longer legally be advised to stay at home, but they are still advised by the UK government to do so for 5 days after testing positive for COVID-19. Earlier on this year, in January, in England, it was no longer a legal requirement to wear a face covering, but again, people are advised still to wear one in crowded and enclosed places. Guidance to work from home has completely ended, and it's no longer a criminal offence for an individual who has tested positive for COVID-19 to attend the workplace. Next month, from the 24th of March 2022, the removal of legal provisions in relation to statutory sick pay from day one will no longer apply, and they'll go back to applying from day 4 of absence instead. And then from the 1st of April, we're seeing more restrictions being dropped, and actually there'll be no more free mass testing in the UK, and there'll also be the removal of all guidance in relation to COVID passports to get into certain venues and areas. There'll also be the removal of health and safety requirements for employers. So at the moment, employers are explicitly required to consider COVID-19 as part of the health and safety risk assessment, but that will fall away from the 1st of April this year. So also another issue for employers, that working safely guidance that currently been in place for almost 2 years now will be replaced by new public health guidance that will be issued on the 1st of April. We currently have no idea when this guidance will be released. We can only hope that it comes out at least a week or so in advance of the 1st of April, but it'll probably be the night before. So despite all of this, employers are still advised that they should continue to consider the needs of vulnerable workers. Of course, COVID-19 poses much more of a greater risk to those individuals when considering them returning back to the office. So obviously, what does this mean for you? The end of COVID restrictions and the legal obligations does not prevent employers themselves implementing their own more restrictions and their own rules on employees, and having policies that put certain measures in place to best protect from COVID-19. The UK government's Living with COVID plan essentially says that they want to give each UK employer the power themselves to take responsibility when it comes to COVID-19 and implementing appropriate measures that they see fit. Each workplace is completely different, and each employer has the power to implement certain policies and measures to ensure that it's effectively mitigating that risk against COVID-19 spreading. The lack of any legal rules and the changing rules in society when it comes to COVID-19 is likely to result in individuals attending workplaces when they do actually have COVID-19 or are, of course, displaying symptoms of it. So that's going to mean that it's going to be very much a balancing exercise for employers to strike the right balance between living with COVID but ensuring that the health and safety of all of its staff is best protected. Just moving on to the next slide now. So how do you effectively manage these issues, and what should you be doing when looking at seeing employees returning to the workplace? So in the first instance, what we would always recommend is that you review any existing policies that you have in place. Adapt them to this changing COVID environment, see what can be dropped or what still needs to be in place to ensure that health and safety is maintained. In doing that, of course, you're going to have to consider your communications to your workforce. Issuing revised communications in line with the new government guidelines, the fact that measures have been changed, and what you intend to do to effectively manage COVID-19 in the workplace against all of that. As well, obviously, as following government guidance as and when it's finally issued, hopefully well before the 1st of April, so we can get to grips with it. Policies. So I've got on the slide there, you'll see face coverings and vaccination status, which I will focus on, as well as other matters. Face masks and face coverings, as I said, no longer a legal requirement in England, and that was dropped last month. But what we are finding is a number of employers are still asking employees to wear face coverings in workplaces, especially if they're in a crowded area where social distancing can't be maintained. And it may be that you want to implement a policy where face coverings are required in communal areas, and then of course when employees have reached their own office or their own workstation, they're able to take it off and work without a face covering for the rest of the day. You may also want to keep in place certain rules in relation to sanitisation, so hand washing, and then any other safety measures that you might have in place at the moment in time. You may also decide that you want to have a policy in place in which an individual that does test positive for COVID is required to stay at home and not attend until they have taken a negative lateral flow test. You might also want to consider in doing that so, and having such a policy, that you will purchase home testing kits yourself, give employees that are displaying such symptoms a test so they can be reassured that they don't have it, or of course they can't attend work if they do. So of course, as you can see, this is something that's moving at pace, and it has been moving at pace ever since the pandemic started nearly 2 years ago. And I'm sure that we will see further direction from the government, and we like to hope that we do, in the form of the new public health and safety guidance that will be issued before the 1st of April. And of course, if there is a new variant that is stronger and that vaccines aren't amenable to and can't fight, then we may see the government take a different direction with this. But it does appear that, the government are looking to ways that we should now be living with COVID and scrapping certain rules. But of course, that does not mean that COVID is gone for good. So with that in mind, it will of course be sensible as an employer in the backdrop of your health and safety obligations to staff to ensure that you do have clear policies in place, keep an eye on the market and what other people are doing, and of course adapt to any other changes that may be implemented. Whilst the government have lifted the legal duty in relation to self-isolation as from today, you of course need to consider what you need to do to ensure that health and safety is effectively managed and the exposure to the spreading of the virus is reduced. So that might include, from a health and safety perspective, updating your risk assessments in light of, the end of isolation being a legal requirement. Or what you might do is you might decide that you keep your status quo as it is for the time being, and those, like I said, do test positive for COVID-19 are encouraged to work from home and not attend the office until they have taken it to test. In relation to testing, you might ask staff that they are still required to take a lateral flow test before they come into the office, and the night before or the morning of. And of course, you need to consider in doing that who will pay for the tests, now that the government have said that there'll no longer be free mass testing available as of 1st of April. Of course, another major issue for you to give weight to is how you will treat those that fall within the clinically vulnerable category in light of self-isolation rules, and those that may still feel extremely uncomfortable in coming back to work and have done so ever since the start of the pandemic in March. Quickly, in relation to vaccination status, this is something that we did speak about in relation on another webinar towards the end of last year, and obviously quite a topic of much debate. But unlike many other countries, the UK government have not legislated in relation to COVID-19 vaccinations. They haven't made them compulsory, only say for individuals that are working in a care home setting. The government had announced that they would require NHS staff to have a mandatory vaccination, but they've kind of backpedaled on that. They consider that it's no longer proportionate, and they're now looking at consulting on revoking those regulations. So without specific legislation in relation to mandating vaccines, it would be hard to refuse an employee's attendance at the office because they have not had a vaccination, mainly because it could be considered unlawful discrimination under the Equality Act, mainly if that person's reason for not having the vaccination is because of a disability, or perhaps because of other protected characteristics such as a protected belief. We're yet to see any case law as to whether or not being an anti-vaxxer is a protected belief for these purposes, and I suppose we'll have to wait and see. But from a practical perspective, mandatory vaccination is not always the complete solution here. Obviously, individuals that have had the COVID-19 vaccination, have been double jabbed, triple jabbed, are still testing positive, and they can still catch COVID-19, of course, with very mild symptoms in most cases. But also, secondly, other measures that you might have in place in relation to hand sanitisation, social distancing, employees wearing face masks in communal settings, might have exactly the same effect as effectively managing and limiting the risk of COVID-19 spreading in the workplace. So instead of implementing a mandatory policy, what we're seeing is a number of UK employers actually introducing policies that simply encourage their staff to to receive the vaccine. And of course, if you did want to implement a policy in which you did make it mandatory in relation to mandatory vaccination or mandatory testing, there'll be a whole host of things to consider. The main one would be that you'd have to carry out a risk assessment to justify why you consider it proportionate against all of those other safety measures that you've already got in place. Added to that, there's a whole host of GDPR issues, because of course you will be processing, collecting, managing special category personal data for the purpose of the GDPR, which I will not go into because it's a whole topic in itself. But obviously, in all cases, it's essential to have a process here, and understand that hesitant employees might want to discuss their concerns if you are considering implementing such a mandatory policy. Of course, consultation with all staff is mandatory when it comes to introducing substantial measures in relation to health and safety at work and managing those. And if you were to implement a mandatory vaccination policy, then you would need to consult with your staff as to the reasons why you considered it appropriate and proportionate against your health and safety obligations and requirements. So lastly, I thought it'd be interesting to deal with those staff that refuse to return to work over COVID. Now, Joe's going to be talking about this in a lot more detail, and I'll briefly mention it. But staff are returning to UK offices in high numbers, and the highest numbers we've seen since the start of the pandemic. But of course, I'm sure all of you are aware that office numbers remain far below what they were pre-pandemic levels. Aside from health and safety concerns, employees may be reluctant to return to the workplace for a whole host of other reasons. Perhaps they've relocated away from where the office is currently situated, or they've decided that actually working from home now just fits in with my routine, especially my childcare commitments, and I don't want to come back to the office on a 5-day-a-week basis. Despite the changing COVID rules, obviously employers will need to discuss and consider returning to work with all employees, but give particular regard to those that fall within that critically vulnerable category, who naturally will all remain quite cautious about returning to work. COVID has not gone away just because there's no longer a legal obligation to self-isolate. So how to deal with employees that refuse to return to work? I suppose in the first instance, the best approach would be to meet with them to better understand what their concerns are, be sympathetic to those concerns, and make it very, very clear everything that employers are doing and what's being done in the office space to manage the risk of COVID-19 spreading from a health and safety perspective, perhaps sharing with them a copy of your risk assessment that you've done. Of course, we'd always advise that you follow the latest government public health advice. And like I said, that's soon to be released, hopefully well before the 1st of April when the government have said it will be shared. Specific reason for the employee obviously refusing to attend work needs to be explored, and we need to also explore whether or not there's any kind of discriminatory aspect or discriminatory risk in them refusing to return to work. I think the main one with a clinically vulnerable individual will be the potential disability discrimination risk that may be available. But in terms of those that simply refuse to return to work with no good reason, I think taking account of unfair dismissal rights for those that have, of course, been with you for more than 2-year period and therefore obtain them, a fair reason and a fair process would need to be followed by any employer before they considered terminating that employee's employment for a refusal to return to work. If you made it a requirement that they had to, perhaps on a 2 days a week, 3 days a week basis, and an unfair dismissal claim, you might have an uphill battle with it if you cannot demonstrate that you had taken all measures and tried to resolve something or reach a remedy with the employee as to their refusal to return to work. There will need to be consistency with this to ensure that you're taking a consistent approach with all employers. And of course, I do appreciate that, with a global workforce, consistency might be an issue here, given that England are now very much out of step with everybody else in the world when it comes to COVID restrictions. But of course, I think the main issue here is just to be reasonable and proportionate and considering everybody's concerns, especially those that fall within that vulnerable category, but also taking account of the legal obligations that you have and the government guidance. I'm now going to be turning over to Joe, who's going to be talking to you about more return to work issues and, of course, the 4-day working week.
Thanks, Millie. And I should say there's a box on your screen for any questions if you want to write them there. Over to you, Joe.
Thanks, Paul. Thanks, Millie. Hi, everyone. So Millie's given a really good overview there of some of the sort of COVID-specific issues in terms of the return to work. I just wanted to talk fairly briefly about some of the more practical issues. As we've said, today marks the day when the last of the restrictions in England, at least, are being lifted, which is fantastic in terms of getting back to, in inverted commas, normal. One of those restrictions, as I'm sure everyone will be aware, has been the requirement to work at home for health and safety reasons to minimise the spread of COVID. Those restrictions have been on and off a few times in the UK. So now that those requirements are no longer in place, they were removed several months ago in England. One might assume that means that everyone's going to be returning to work as per normal. Everyone will be in the office 5 days a week, and nothing will have changed. But of course, as everyone is finding out and has been finding out over the recent months, that's just not going to happen in a very significant amount of workplaces, and we're really looking to adapt to what, that buzz term of the new normal, and trying to work out what that new normal looks like for employers, taking into account the expectations and the interests of their employees, because ultimately the way we work has changed forever, and the attitudes of employees in terms of what they see as being the right way to work has shifted, and it's vital for all employers to be able to make whatever changes and adaptations they need to make sure you're retaining employees and maintaining yourself as a positive place to work, and somewhere that looks after its employees and has their employees' interests at heart. So I'm sure a lot of you are already or have been thinking about what the plan is in terms of the return to work, and in most cases that sort of plan will already have commenced. In a number of workplaces, so things like manufacturing or places where the employees do need to be physically in the place where they work in order to do their job, it may be that the only option is a full return to the office 100% of the time, and there are good business reasons for that. I think in probably the majority of your cases who are watching today, you'll be used to more of an office environment, and ultimately that reasoning doesn't really apply. So an analysis needs to be carried out as to what is the right thing, both for business but also for employees and keeping employees on board. And that sort of goes the full spectrum of maintaining full remote working, which a lot of businesses, particularly tech businesses, we're seeing moving to that structure, which has its own issues to think about, all the way to full time back in the office, but then some kind of hybrid in between situation where people are able to work from home some of the time, but are required to come into the office for a number of days per week. And that tends to be the theme that we're seeing, is that most employers in office environments are looking to implement some kind of hybrid working arrangement. Now, it's important to be aware that you may have an idea of what the right thing to do is for the business and for employees, but ultimately you should be careful about expecting that you can implement that at the company's discretion and not expect any pushback, and not be required to at least speak to the employees and consult with them about that proposal and sell it to them. There are going to be risks if you look to implement something, particularly if it's a significant change to what people are used to, without getting their views and without getting their input on the proposals. One thing that a lot of employer clients seem to overlook is what's stated in employees' contracts. So it's an interesting situation, because the majority of employment contracts, at least historically, will tend to have a clause in there that refers to where an employee's place of work is. And unless they were historically remote workers, that would tend to say you will normally be expected to work at the office of the company at this address, or within London, for example. Now, obviously, there have been mandatory rules in the UK whereby that is not legally possible for a period of time, and therefore it was completely acceptable and indeed legally required for us to necessitate employees working from home, notwithstanding that it says they will work from the office in their contract. But it's just something to be aware of as an employer when looking to implement these policies, because now that we're getting people back into the office, we need to see whether that's consistent with their contract and whether we need to be making taking steps to make amendments to their contracts to ensure there's no argument that by either making them return to work or requiring them to continue working for 2-3 days from home, for example, we're not inadvertently in breach of their employment contract. And for example, if we then in the future look to discipline someone for them failing to comply with our new policy, that they can't turn around and say, well, hang on, you want me to work remotely 2 days a week, but my contract says I should be working 5 days a week in the office, therefore you breach my employment contract. So with any policy where things are changing, as a minimum, we would want to be looking at the employment contract to see whether there needs to be a change to the terms and conditions of employment, and also, as Millie mentioned earlier, putting in place the right policies that explain the reasoning for the policy and why that's being put in place and exactly what the parameters of it are. In terms of the changes that are needed to the contract, whether that is necessary may depend somewhat on how mandatory the policy is. So if you have a very broad optional policy, which is you can come in as much as you want and you can work at home as much as you want, then it may be that a change to the employment contract isn't needed because you're essentially letting the employee do whatever they want within those parameters. But effectively, if you are implementing what is essentially a mandatory policy, then you may well need to amend those employment contracts and really get employees agreement to those changes in advance, if at all possible. So once you've decided what the policy is and how how you see the new normal being within the workplace, the next thing to think about is, well, how are you going to manage that and monitor attendance? Is it going to be a situation that's purely based on trust? So you put in place the policy and you just hope and trust that people are going to do the right thing and comply with the policy and continue carrying out their jobs in the right way? Or are you going to have some kind of some way of managing and monitoring their attendance in the office? You may have a clocking in system, you may have a sort of rota system where agreement is reached about which days employees are going to be in the office and which days they're going to work from home. And that's quite important too as well. If you are going to have a hybrid policy, some controls over who's going to be in when are often quite useful, because you may want to maintain at least a minimum number of employees in the office at any one time, in case of emergencies or in case of particular tasks that can only be carried out physically in the office. Again, GDPR is something which is way too big a topic to discuss in detail on this webinar. But obviously, if you are intending to put in any kind of monitoring arrangements, so literally monitoring their attendance, whether it's by checking whether they've swiped into the office or even so far as sort of assessing CCTV cameras to see whether someone's been in the office, you have to be very aware of GDPR data protection issues and privacy issues when looking into it to implement that kind of a policy. So you should obtain appropriate legal advice whenever anything as intrusive as that might be on the cards, essentially. So, and one of the other big issues that we're seeing our clients face at the moment as they look to get people back into the office is, and some of you may have encountered this yourself, people just no longer being in the country and the employer not knowing about it. And it sounds faintly ridiculous, but it happens a lot more often than you might think. Employees have been working from home or remotely 100% of the time for up to 18 or even 18 months or 2 years, and they may have decided without really thinking about it that means it's absolutely fine for them to go home to France or go to the Bahamas because it's a much nicer place to work, as long as they're continuing to do their job and do their hours, then why should that be an issue? I'm working remotely, so it doesn't matter where I am. this is a really big issue and a significant risk area for businesses, and it's something which I see as being a real hot topic this year as the return to work continues. Sort of at a high level, there are potential legal and very potentially significant tax issues in having employees based overseas. From a legal point of view, any mandatory employment law that applies in that jurisdiction will, in most cases, apply to the employment of that person, even if they're working for a UK employer. So there may well be very, for example, generous employment laws, which means it makes it more difficult to terminate that employee once they're abroad. There are also issues, as I say, from a tax point of view. So there may be an issue around potentially creating a permanent establishment from a corporate tax point of view, and also obviously payroll tax issues. So if you have an employee overseas, you might still be paying through the UK payroll, but under the rules of the local jurisdiction, you may have an obligation to pay them through a local payroll instead. So, this is going to be a really significant issue as things progress. And I think, the number one piece of advice here is to carry out an audit to work out where people are. So if there's anyone that hasn't been returning to the physical office and you don't know why, or there is a number of people working remotely and you don't necessarily know where they are, carrying out an audit of where people physically are located is going to be really quite important as the year progresses. That you may be in a situation if someone has left the country without telling you. You may potentially be in a situation under their employment contract and under UK law that you are able to terminate their employment under the terms of the contract, for example, because it's legally impossible for you to employ them if you don't have a business presence in that country, and potentially they've breached their contract by not being physically present in the UK. But ultimately, we do strongly advise that if you're at that position where you might be considering that you may well need local advice from a lawyer in the country in question, just to double check that there are no major issues from a local legal perspective. That's just a bit of a sort of whirlwind tour through some of the practical issues on return to work. I just wanted to talk a bit about another sort of buzz term that we're seeing at the moment is, really is sort of the press are getting hold of it quite a lot at the moment, which is this concept of a 4-day week. And I think probably if you asked me 6 months ago, I would tell you that it was a bit of a sort of flash in the pan and a bit of a fad. But I think it's got beyond that stage now, and we are in the process of advising several clients on potentially implementing some type of a 4-day week. And whilst it seems quite a simple concept, there are quite a few issues to bear in mind. So just briefly, in the UK, there's already a trial going on with a number of employers for 6 months where they put in place a 4-day week on trial basis. Now they refer to it as 100-80-100. So that means the employee continues to receive 100% of their pay, but is only required to carry out 80% of their contractual hours in exchange for guaranteeing 100% productivity. Now, to my mind, that in itself is a bit of a difficult thing to get your head around, because if you're saying that employees only need to work 4/5 of the number of hours they would normally be working, but that they need to be 100% productive, unless they were less than 100% productive when they were working full-time hours, that doesn't really work. And I think one of the themes that we're going to see out of this 4-day week trial are potentially disputes around whether it's actually a good thing, and whether it's the right thing for employees. So it's important that if you are looking to implement something like this, that it's done in a careful way and in a way that you're looking at all the potential issues. There's an alternative way of doing a 4-day week, which would essentially be 100-100-100, which is 100% pay. They continue to work 100% of their hours, but in a condensed 4-day week. And there are certain employers who are doing it that way rather than in terms of reducing the number of hours required. So, that's the number one question is, what kind of a 4-day week are you looking at? Second question is it going to be optional or mandatory? So like I said previously, in terms of implementing a policy and whether it's something which is sort of required or whether it's optional, if you're implementing a mandatory policy that people work a 4-day week and, for example, do not work on a Friday, then you're almost certainly going to need to amend their contracts to implement that and get their agreement to that, because most employees' contracts will say they work 5 days a week, Monday to Friday. And whilst you may see it as a great positive for the employees that you're reducing it to a 4-day week, and in some ways it will be a positive thing, people have different situations and different requirements of their work, so not everyone is necessarily going to be happy about it. So you really want to be carrying out a consultation with employees before you implement it, and particularly where it's a mandatory change, making sure that their contracts are amended and you get their agreement to that change as well prior to it being put in place. There's a number of sort of employee relations type issues to be aware with this kind of a proposal. You may get allegations of discrimination, so people with particular family caring obligations or religious requirements which perhaps need them not to work on certain days or to work on certain days so that they can take certain days off, may have an issue with whatever your proposal is in terms of the 4-day week. So that's why it's really key to have that sort of consultation to look to get any comments from employees about whether they see that as something that can work for them. And another issue which you need to be aware of is if you have anyone who's already working part-time, so for example someone who's doing a 4-day week on reduced pay already, and you're looking to implement a 4-day week but on full pay, you need to decide how you're dealing with those people who are already working a part-time week for less pay. Most likely you're going to need to bring them up to full-time pay, because obviously you can't you can't treat a part-time worker less favourably than a nominally full-time employee, and obviously they're not going to be happy if their colleagues are earning full-time money for part-time work. And I just said, what if it goes wrong? Again, there are definitely positives with the 4-day week, and it's being taken very positively by a number of companies who are implementing it. But ultimately, it's not guaranteed to work. You're making a significant change to people's working arrangements, and you're hoping and assuming that they will be fully productive during those reduced hours. It's possible that it won't work. It's possible that productivity may come down. So you just need to have a contingency plan in place for if it doesn't work. And what a lot of people are doing is that they are doing it on a trial basis. So putting it in place for a 6-month period and making sure that all the communications are clear that it's a trial and that the employer has the ability to go back to the normal way of working and to not go forward with the trial if they decide it's not working. So very important for all your paperwork to be clear on that and give the company as many options in terms of how it's implemented. And obviously, if anyone's planning on or thinking about implementing this kind of a policy, do let us know, and we can help sort of talk it through with you and also prepare the documents. So that was all I had to say, and I'll hand you over to Alex, who's going to talk a bit about the employment bill.
Thanks, Joe. I think that was really interesting. I think one of the points is that a 4-day week means different things to different companies. There are lots of different models out there, so do contact us if it's something you're thinking of doing. We have had a few questions come through, but I'm conscious that we're struggling with time, so we might get back to you directly after this webinar if we do run out of time to go through the questions, but do feel free to keep the questions coming. Alex is over my shoulder here, and he is going to very briefly, well, not very well, hopefully briefly, but he's going to give us a whistle-stop tour of what the proposed employment bill that the UK government's been talking about for some time might bring us. And the UK government is a bit curious about this because there are a number of new rights that they're talking about, but they've been delaying and delaying and delaying. And so we're not entirely sure whether it's something that they particularly want to prioritise. But Alex, over to you.
Thanks a lot, Paul. And yeah, as Paul says, this will be a very whistle-stop tour. So yeah, we know that it's not applicable to Northern Ireland when it does come in. but we do hope that it's going to be published in 2022 because it's been in the pipeline for quite a while now. We know that there's going to be some changes in relation to family rights. In the EU, member states will be required to implement the Work-Life Balance Directive by August 2022, which does include rights for carers and working parents. It just so happens that the UK has promised to match the EU rights for carers, and so it's proposed that carers will be able to take 5 days unpaid carers leave annually to assist with their responsibilities. There will be more detail as to how the right will operate, and that will be contained within the bill, but we can expect to match the EU law at this stage. There's also going to be 12 weeks neonatal leave for parents whose babies are in neonatal care units. And pregnant employees returning from maternity leave will be prioritised for alternative employment opportunities if they are made redundant.
And as you'll probably know, at the moment, if they're made redundant during maternity leave, employees on maternity leave do already have priority protection for any alternative employment. But the big point here is that that's going to be extended to 6 months after the individual has returned to work from maternity leave. So that's quite a long time, and it does mean that if you have any redundancy proposals, you've got to always be thinking whether any of the impacted people, not only are they on maternity leave now, which is something you would readily think about, but were they on maternity leave 6 months ago?
Yeah, that's right. And in relation to flexible working, we can expect some changes as well. We know that flexible working is a real up-and-coming topic, and it's expected that the bill will have a new right to request flexible working from day one. The current position is that an employee has to have worked for 26 weeks before they can make the request, and so changing it to day one obviously ties into the wider concept of new normal and working process in that respect. There's also a higher probability that flexible working will become the default position, and it's interesting to see that being introduced via legislation as well. So that'll be interesting to see. The Good Work Agenda, this has been proposed by the government back in 2018, and it's going to be progressed under the bill, is our current understanding. Workers with variable hours may be able to request a more stable and predictable contract after 26 weeks service. And additional new rights of reasonable notice of working hours and compensation for short notice shift cancellation will likely be introduced.
And this is part of the ongoing debate about gig economy workers and whether they have all of the protections that they should have. But as Alex said, this has been talked about for a few years now, and we still haven't actually had a bill to give these rights.
So we also expect a single enforcement body to be introduced under the legislation. And the plan is, at present, to combine the Employment Agency Standards Inspectorate, the Gang Masters and Labour Abuse Authority, and HMRC's National Minimum Wage Enforcement Team into one body. And the result of that is hopefully that they're going to be more cohesive and action will be taken quicker in respect of the operations that they undertake. For example, the remit of the body will be expanded to include enforcement of statutory sick pay, and holiday pay for vulnerable workers, and the regulation of umbrella companies will also be monitored under or by the single enforcement body. It takes a few years for that body to be up and running. It will take some time for the amalgamation to take effect, but we know that it will be likely introduced under the legislation.
Thanks, Alex. And umbrella companies probably would include PEOs, which have become increasingly fashionable to use for companies that want to hire in the UK and across the rest of Europe, but not set up an entity or have to deal with compliance issues themselves. And there can be some great advantages to them, and in some cases, some disadvantages, like Boston not directly employing your own employees. And if you are thinking of using a PEO, then do let us know, and we can point out some of the pros and cons, and between us decide whether it makes sense in your particular situation.
So there'll also be some introductions in relation to harassment through the legislation. The government has wider plans to introduce a duty on employers to prevent sexual harassment in the workplace. We anticipate that these changes will be introduced in the bill, and this is a result of the Me Too movement in recent years, and how more legislation could be introduced to try and affect changes to make that to impact those issues.
So we could see something similar to the rule in California where managers are expected, where there's compulsory sexual harassment training.
That's right. And in relation to NDAs, we know that they've been there's been news stories about them being abused in relation to sexual harassment cases, and so there could be changes in the bill to prevent the use of NDAs, or at least restrict their jurisdiction.
Okay. Tips.
So tips regulations, the bill is expected to introduce detail as to how tips are distributed, especially with the cashless economy at the moment. It can be unclear sometimes when you are tipping where the tip goes, if it will go to that particular individual who served you. And so it's going to be interesting to see how the legislation will be introduced, and much more regulations are expected for employers in these types of industries, so hospitality, where tips are a big part of the employee worker income. There's also going to be, we anticipate some post-termination restriction changes, and it's possible that non-compete and non-solicitation clauses could be removed from contracts, or in the alternative, there could be a requirement for employers to pay the equivalent of the employee's salary in order to enforce those restrictions. And so that's quite a serious change, and it will have quite big ramifications, especially for senior employees who are subject to those restrictions.
Absolutely. And the government consulted on that last year, but we're yet to know what their conclusion is as to whether there'll be no change. As a lot of people on the line will know, post-termination restrictions, if drafted properly and if justifiable, are often enforced in the UK, and it's not at all unusual for them to be enforced, and so the government is obviously thinking of potentially changing that. So thanks, Alex. That was really helpful. We'll let you know, of course, when we do get a bill, if and when we do get a bill that sets out these issues. But as I've mentioned before, we've been told we will when parliamentary time allows, whatever that means. But what we will have are cases going through the courts that will potentially change the law in themselves. And Ruth is going to talk us through some of these. And one of the more contentious areas is the issue of transgender rights and how that interrelates to other protected characteristics. Ruth, do you want to tell us about the Mackworth case?
Thanks, Paul. And it's great to be here to talk to you today and to finish off today's webinar. So I'm going to speak today about the Mackworth case, and I'm sure you will all be aware of and have potentially had to deal with the clash in the workplace between religious belief and sexual orientation. But more recently, the heat is now in the clash between the proponents of gender rights and those with gender critical views. Last year, the Employment Appeal Tribunal found in a case called FourDay that gender-critical beliefs such as the view that sex is fixed and should not be conflated with gender identity were protected philosophical beliefs and were worthy of respect in a democratic society and capable of protection under the Equality Act in the UK. And so in that case, the EAT found that the tribunal had incorrectly dismissed Miss FourDay's claims of direct discrimination and harassment because of her gender-critical beliefs. And in March this year, the Employment Appeal Tribunal will consider a similar case in relation to the tribunal decision in Mackworth against DWP. So looking at the facts, Dr. Mackworth is a Christian who believes that God created only males and females and that a person cannot choose their gender. He also does not believe that people should be accommodated or encouraged in what he terms their delusional belief of being able to change gender. He was engaged for around a month by Advanced Personal Management Group UK Limited, so APM, to work as a health and disability assessor for the DWP. And the DWP has a policy of addressing its transgender service users in their presented sex in order to ensure that they are treated with respect and in accordance with their right not to be discriminated against. So whilst he was going through training with APM, Dr. McCareth stated that he could not refer to someone by using a pronoun or title which did not reflect their birth gender. He argued that this was because God assigned people's gender at birth, and he could not refer to individuals by gender that was different to their God-given sex. After he carried out a few assessments, he was asked by a manager whether he could comply with DWP's policy, and he made clear that he could not do so. And shortly afterwards, he chose to stop working under the contract. The DWP had considered whether there were any alternative roles which Dr. McCareth could take to avoid having to deal face-to-face with transgender people, but there were no alternative roles available. And he was asked for a final time whether he could comply with the policy, but he refused, and this was taken as a resignation. He then raised claims for harassment, direct discrimination and indirect discrimination against both the DWP and APM, and he relied on two beliefs which stem from his Christian belief in the truth of the Bible. Firstly, lack of belief that it was possible for a person to change their sex or gender, and that it would be irresponsible and dishonest for a health professional to accommodate or encourage a patient's impersonation of the opposite sex. And he stated that his beliefs prevented him from complying with the DWP's policy of addressing service users in terms of their presented sex, including using their preferred name and also their preferred pronoun. And the tribunal rejected those claims, finding that Dr. McCareth's stated belief in and conscientious objection to transgenderism was incompatible with human dignity and conflicted with the fundamental rights of transgender individuals. And the tribunal considered that during the course of the hearing, it had heard evidence that many of the DWP service users had mental health issues, and that in this context, misgendering was likely to be particularly harmful. It also took into account the fact that no practical means had been identified of avoiding any possibility of Dr. McCareth's beliefs causing offence to a transgender service user. And importantly, it was not possible to operate a triage system to avoid transgender individuals being assigned to Dr. McCareth, since such a system would itself carry a serious risk of causing offence to the individuals concerned. And an appeal has been raised as a result of this. I think it's also important to note that the tribunal held that this decision was compatible with the European Convention of Human Rights, as the right to manifest a religion or belief is subject to the protection and freedoms of others. So I think this is a really interesting case, and I'm looking forward to kind of hearing how the Employment Appeal Tribunal interprets it, especially when we look at people who are holding gender critical views without necessarily being a conscientious objector or impacting on other employees' rights. And this is particularly important where employers have implemented policies on equality and diversity, and what is becoming increasingly more common, having policies in relation to the use of pronouns. In the McCareth decision, the DWP was able to show that it had a clear equality and diversity policy in place, which was communicated to the contract workers before their induction. And it was also able to show that was given to Dr. McCareth. It was also and I think also going forward it'll be interesting to see whether the EAT, when looking at the McCareth decision, addresses the issue of prohibiting compelled speech in this context. This is specifically since the Supreme Court's decision in Lee and Asher's Bakers, which is, I'm sure you're all aware of, the gay cake case, where it was found that the Christian owners of a bakery did not discriminate against a gay man when they refused to supply him with a cake decorated with a message in support of same-sex marriage. The Supreme Court had found that to find there was discrimination in that case would lead to compelled speech by forcing the bakers to produce a cake with a message with which they deeply disagreed. And this issue of non-compelled speech is likely to only continue after the European Court of Human Rights decision to find the Mr. Lee's appeal to the European Court of Human Rights found his appeal to be inadmissible, and that there have been kind of comments that this decision has been interpreted as prohibiting compelled speech, including in relation to pronouns. And I think given the For-Starter decision, which I mentioned earlier, and the fact that gender critical views are now accepted as being protected as philosophical beliefs, I think it'll be really interesting to see how the EAT addresses this in the McCarthy decision, and we'll certainly, keep it in our minds and keep you updated, as it is such a topical issue at the moment.
I think that's right, Ruth. And one thing I have really noticed, I think in the US, asking people to provide their preferred pronoun is more common than in the UK. And I would just say to anyone on the webinar that I would be careful. It's fine to give it as an option, but I would be very careful about requiring it, for example, in for job applicants, because then it would be compelled. Then it would be compelled speech and be a lot more dangerous than simply allowing people to show their preferred pronoun if they choose, but without any pressure from an employer.
Thanks, Paul. So the next case I'm going to talk about looked at the issue of changing terms and conditions. So in this case, it involved the High Court granting an injunction restraining a supermarket, Tesco, from withdrawing a contractual entitlement to enhanced pay by means of termination and re-engagement, or also known as fire and rehire. It was held that there was an implied term which prevented termination on notice for the purpose of removing or diminishing the employee's entitlement to that benefit. And just briefly, I'll give you the facts because it is quite relevant to this case. So the trade union here, USDAW, is recognised by Tesco for collective bargaining. Between 2007 and 2009, the trade union and Tesco agreed arrangements for retained pay, which became an individual contractual entitlement. The reason for this agreement was Tesco's programme of reorganising its distribution centres, which involved some closures and some relocations. And Tesco decided that they didn't want to lose all of their existing employees through redundancy, and so negotiated retained pay as an alternative to a lump sum redundancy pay and as an incentive for staff to relocate. The contractual reward package was given as a monetary value, and the difference between the value and the value of the new terms and conditions was protected. Tesco also communicated to staff and made clear that the individual entitlement to retain pay would remain for as long as they were employed in their current role, could not be negotiated away, and would increase each year in line with any general pay rise. And in a joint statement between the trade union and Tesco in 2007, retained pay was described as guaranteed for life. Then in 2010, a collective agreement stated that retained pay would be a permanent feature of an individual's contractual entitlement and could only be changed through mutual consent or on promotion to a new role. In the event an employee requested a change in working patterns, the premium payment element would be adjusted, but the basic entitlement to retained pay would remain. The employees who then subsequently relocated accepted the retained payment rather than a redundancy payment, and they argued that in many cases they relocated up to about 45 miles away, and they said the retained payment was, one of the main reasons that they decided to relocate. Then in January 2021, Tesco formally announced its intention to remove retained pay. It offered a lump sum payment of 18 months retained pay in advance in return for giving up the entitlement, failing which the employees would be dismissed, and then offered new terms excluding the retained pay. So the trade union applied to the High Court for a declaration that the impacted employees' contracts were subject to an implied term, preventing Tesco from exercising its contractual right to terminate for the purpose of removing or diminishing the employee's right to retain pay, and also sought an injunction preventing Tesco from terminating the affected contracts. and the High Court granted the relief sought. Firstly, it looked at whether there was an express term on retained pay, and it considered the use of the word permanent in contractual entitlement to retained pay. And it decided that based on the construction, if you were to look at just permanent, it would simply mean for permanent as long as a particular contract endures. And so that would not conflict with any right to terminate on notice. However, if you take into consideration the background and the intention of the parties, the meaning of permanent really did show that it was to last for as long as the employee was employed by Tesco in the same substantive role that they carried out. And so looking at that interpretation, there was an inherent conflict between the permanent right to retain pay and the contractual right of Tesco to terminate on notice for the purpose of removing that right. So then the court had to decide whether a term could be implied into the contract to resolve this conflict. And the employees sought to argue that their contracts of employment were subject to an implied term, that Tesco would not exercise the right it would otherwise enjoy to give notice to terminate such contracts for the purpose of removing the right to retain pay. And the High Court concluded that, based on the facts of the case, that the term should be implied. And the court was satisfied that the implied term sought by the employees was capable of clear expression. It was reasonable in the particular circumstances of the case and operated to limit rather than contradict the express contractual term to contractual right to terminate on notice. But it was important to note that the High Court here made clear that Tesco could still terminate an infected employee's contract for good cause, for example, if that individual was made redundant or if they were dismissed for gross misconduct. And I think going forward, this case is particularly important to remember, where employers are going to offer a contractual entitlement to employees, and it's really careful. You need to be careful in the construction of that express right to show how long that will last for. And although the Tesco decision is obviously fact specific, it is important to consider carefully how to communicate contractual changes and how to build in flexibility when offering an entitlement which could be construed as permanent. I think this case also shows the risks in adopting the fire and rehire approach when changing contractual terms, and it is one that I'm sure trade unions and employee representatives will try to rely on going forward. So it's just one to be aware of when you are engaging those discussions. And I'm just conscious of the timing, so I'm just going to quickly cover the holiday pay case that came out recently. And as I'm sure you'll all be aware from calculating holiday pay or trying to anticipate what holiday entitlement will be, this has been an issue that's been a hot topic for some time. And I'm going to focus on the recent decision of the Court of Appeal in Smith against Pimlico Plumbers. In this decision, the Court of Appeal held that the right to paid annual leave under Working Time Directive is a single composite right, rather than a right to leave and a separate right to payment of that leave. So this means that a worker who had taken unpaid leave, having been told that he had no right to paid leave, but who had not invoked his right of payment until his contract terminated, was entitled to bring a claim in respect of unpaid annual leave accrued throughout his engagement, both taken and untaken. And I think that I'm conscious of timings here, so the key takeaway was that the Court of Appeal found that even though Mr. Smith had not pled a claim for payment in lieu of holiday, not taken at the date of termination, the Court of Appeal found that the tribunal had erred in confirming that the European Court of Justice decision in King against Sash Window was focused solely on a compensation for leave where the worker did not take the leave. So the European Court of Justice decision in King could also be read to encompass workers who have taken leave but not been paid for it. And then looking at the King decision, on the basis of the facts, the Court of Justice had considered whether it was compatible with EU law for a worker to have to take leave first before establishing whether they are entitled to be paid. It had regarded it was clear that the right to annual leave and the right to a payment on that account were two aspects of a single right, not two distinctive entitlements, and it had relied on the established principle that the right to paid annual leave could not be lost unless the worker had been afforded the opportunity to exercise that right. So in the Court of Appeal's view, Mr. Smith's claim that he had been denied paid holidays from the outset should, in light of the Court of Justice decision in King, be construed as a claim that he was denied the single right to paid annual leave because his employer had disputed the right and refused to remunerate his leave. It was not necessary for him to specify whether the leave was untaken or taken but unpaid, because the taking of unpaid leave could not discharge the employer's obligation to provide paid leave. And the employer's approach had prevented Mr. Smith from exercising the right throughout his contract. So this meant that overall this meant that Mr. Smith had an accumulation of untaken leave over a period of 6 years. The court also expressed a view on the issue of a series of deductions. At the moment, the case of Bear against Bear Scotland states that a gap of more than 3 months between holidays will break a series of deductions. This is in contrast to the Northern Irish Court of Appeal decision in Chief Constable against Agnes, which held opposite, and there is no 3-month break rule. And in Smith against Pimlico Plumbers, the Court of Appeal expressed a view that Agnew was preferred, so the Northern Irish case, and that a series of deductions would not lead to a series of deductions is not ended by a gap of more than 3 months between unlawful deductions. So I think this is a really important case, again, where an employer is working in the gig economy, or you have any independent contractors that you might be concerned about their employment status, then you should really be aware of this, especially where there's potentially individuals where the company has denied worker status and so not paid holiday pay. And I think we're probably expecting a flurry of new claims to be raised before employment tribunals, or potentially for applications to be made to amend existing claims. It's also important to note that the claims to claims to taken but unpaid leave will accrue throughout employment until the worker is afforded the opportunity to take such leave. And so unless that is given to them, then they will crystallise on termination. So in this case with Mr. Smith, it's going back 6 years. But I think also, just quickly, to caveat this decision, this case was looking at the European leave, so the first 4 weeks, not looking at the 1.6 weeks additional in the UK. So it's just looking at that. So the series of deductions for the additional 1.6 weeks leave have a 2-year backstop, so that's unaffected at the moment. And also just to remember that the Pimlico ruling applies to cases where the employer denied the right to holiday pay altogether, and not to claims where the worker claims to have been underpaid. So another case in the saga of holiday pay, but one to be aware of as well.
Thanks, Ruth. As I suspected, we have run over. So we will, and so everybody who's written a question in the box, we will contact directly with an answer. And I can assure you that everybody will be sent the slides, and there will be a recording of this webinar available for anyone to listen in their own time. I hope you found that helpful. Thanks everyone for joining, and I hope you have a good rest of the day and rest of the week. Thanks everyone.